Okay, so welcome everyone to those who don't have a flight. It's a pleasure to have you with us. My name is Benoit Dupont. I'm a professor of criminology here at Université de Montréal. And welcome to this panel on cryptocurrency investing, where we'll teach you how to turn $500 into $1 million overnight. Yeah. So no, more seriously, the panel is really on blockchain and the use of blockchain by the legal community to most notably ensure data security. So we have three guests today on this panel. The first one is Marina Teller. She's a professor of private law at Nice Côte-d'Azur, Université Nice Côte-d'Azur. I'm not going to say Nice Côte-d'Azur University. She leads the master's degree in banking law and fintech and a research program called Deep Law for Deep Tech with Frédéric Marty from CNRS. And she also runs a 3IA chair dedicated to smart technologies and AI with work at the crossroad of deep technologies and deep law. So welcome, Marina. Our second panelist is Daniel Amyot. He's a professor at the School of Electrical Engineering and Computer Science at the University of Ottawa, which he joined in 2002, and I think before that you were a senior researcher at Mitel Networks. You have published extensively on requirements engineering, software engineering, modeling, regulatory compliance, and healthcare informatics. And I think you led the ITU-T user requirements notation standardization initiative. And I've got a fascination for standards and standardization exercises because I think it intersects between law and technology and norms, and that's fascinating work. So maybe you're going to talk to us about it a little bit. And finally, it doesn't need to be introduced, but Jeremy Clark, associate professor at the Concordia Institute for Information Systems Engineering. He holds the NSERC Raymond Chabot Grant Thornton Catalaxy Industrial Research Chair in blockchain technology. So he's our deep tech expert on DeFi blockchain. He got his PhD from University of Waterloo with a gold medal dissertation on designing and deploying secure voting systems, which was the first cryptographically verifiable system used in a public sector election. So thank you to you all for accepting to sit on this panel. And I think we agreed on a sequence of short presentations. So first, Jeremy is going to start with the kind of technical background, and then Danielle is going to give us a perspective on energy and a specific application, and then finally Marina is going to give us an example, a use case of the use of blockchains in the justice system with the deployment for an app on domestic violence. So if you want to start, Jeremy, thank you very much.
Sure. Should I take the mic? Yes. Okay. All right. Well, thank you very much. It's a pleasure to be here. So yeah, what I'll do is I'll try and give you the sort of technical background. Obviously, I'm not going to go deep into the details, but I think there's two principles that you can understand that explain, 95% of what's going on in terms of blockchain. So the two principles are decentralization and low barrier to entry. So I'll start with decentralization. So the best way to maybe approach it is just to think about digitization. So you have a lot of industries or court systems and things like that where 15 years ago, 25 years ago, it was paper-based processes. Now it's digitized. It might be a cloud computing kind of architecture. It might be servers that are run by a particular government agency, a firm, a company. And when you digitize something, there's always a computer that has that information. Okay, so it has the data that's being stored. It's running the processes that you want it to run. And it has a physical location. It has an owner. There's probably a legal entity that is in charge of that computer. So it kind of has a jurisdiction, if you will. Okay? So the idea of decentralization is, well, what if you had a computer that wasn't a computer, but it was kind of like a network of thousands of computers around the internet? And they'll do exactly the same thing that a cloud computer will do for you. So if you want to store data, they'll store your data. If you want to run computations, they'll run computations. If you want to create a financial service, You write the code for what it should do, and they'll run it for you. Okay, you just push it to that network, and they run it. And there's no one in charge. Basically, all the computers will execute every transaction. They'll all vote on what the correct outcome will be. And whatever the majority of the nodes on the network think is right, that's what's taken as truth. And then they all update, their copy of kind of the state of the world in terms of all the different things that are running within this system. Okay? So decentralization it's just like cloud computing, it's a digitization, but there's no one entity that's in charge. And so that's interesting for some applications, because some applications you might not have a logical entity that should hold the data, because when you hold data, it's kind of like you're in a position of power, right? You have governance over it, you can control who has access to it, you can turn it on, you can turn it off. And then from law enforcement's perspective, it creates all sorts of jurisdictional issues, right? So, if something is happening in the blockchain space, is that happening in Quebec? So I do a lot of work with AMF, the regulator of financial markets in Quebec, and so they spend a lot of time, thinking about, do we have jurisdiction to even do anything in this particular case? So anyway, so that's decentralization. So that's what's different about it. That's what's new about it. It started with Bitcoin, and so that was just decentralization for the purposes of doing a currency. Ethereum's the most popular general blockchain platform, and it lets you upload whatever code you want. So you don't have to do currency with Ethereum. You can do identity, you can do financial services, and I'm sure we'll go through some of the other applications. Now the other one I'll do a little more quicker is low barrier to entry. So that's the other principle. So if I have the idea for, let's say it's a financial service, all I have to do is write the code. It has to be autonomous and fully digital. So the things that are on a blockchain are kind of like a vending machine, right? It's like a digital vending machine, so it's up there. There's no human in the loop or anything like that. It's just code that runs. But if I have an idea and I can compress my idea into a vending machine style model, all I have to do is write the code, press enter. You pay a small fee for uploading the code, and then I walk away and the blockchain will run it forever. And there's, people could start using it if they like it, if it solves a problem. You could have, hundreds of millions of dollars flowing through, the service that I wrote, right? And I'm not involved beyond just writing the code initially and pressing the button, okay? And that happens all the time now, okay? And so that's also scary from a sort of regulatory perspective, because basically there's no control, right? Anyone can upload anything. And anyone can use it, and we're talking global users anywhere in the world, okay? So, but anyway, that's what's sort of different about it, is you can be your own bank, you can be your own financial service without much effort, and it's decentralized, and there's no one computer or one company that controls it.
Thank you.
Okay. So I don't know if we can share the screen. It's happening. Yep, that works. So thank you so much for staying until the very end. It's very fun to be here. So the topic is really about policing blockchain, and I'm adding smart contracts to the picture. And essentially I'll try to give you a taste of what smart contracts are and how we can actually generate them so that they can run properly on those blockchain-based platforms. So blockchains are quite interesting. So the decentralized nature essentially brings interesting benefits and also drawbacks along the way. So in terms of the benefits, you can store data and programs in what we call an immutable way, so we cannot change that information once it is stored. And also because we don't have centralized control, we can also minimize our reliance on trusted parties involved in various kinds of transactions. Given they are decentralized also, they are by their very nature tolerant to various kinds of attacks and faults where nodes could be malicious or nodes could break along the way without the system going down. Now they have some drawbacks as well. So some of them involve the huge amount of energy and computing power needed to actually make those platforms run. Sometimes they are slow and expensive compared to more conventional approaches. and they are very difficult to update as well, given the immutable nature of the information on them. Now, there is a difference between a legal contract and a smart contract. So legal contracts essentially try to specify terms and conditions of various kinds of contexts, including business transactions. And smart contracts are programs, okay, that can run on various kinds of platforms, including blockchain, and they intend essentially to partially automate the monitoring and also the execution of legal contracts. Now, smart contracts may reside on a blockchain platform, but they don't have to. Okay, the notion of smart contracts go back way before the venue of blockchain, which essentially occurred about 15 years ago. Now, what's interesting is that the use cases for blockchains and smart contracts vary substantially depending on the domains. For example, I've been involved in transactive energy markets with a small company in Ontario. And this is where essentially people from their home can not only consume power, but also produce electricity through windmills, through solar panels, and so on. So they become what we call prosumers along the way. And on this market, there exists essentially bids where people can ask for a certain amount of energy. Say I need 3 kilowatt-hours of power tomorrow between 3 o'clock and 4 o'clock in the morning with this particular voltage. So people can essentially create such bids, and people can essentially get agreements on the fly on those markets, and essentially there is a contractual agreement between the parties that are involved along the way, so the prosumers perhaps, but also the organizations that will transmit the energy in between, so essentially the smart grid. Now you can imagine that we can create thousands of such contracts on a daily basis on any intelligent grid, and we don't want necessarily to involve lawyers for all of them because they are very short-lived. Okay, they are very small contracts, and what's good about those contracts as well is that they are monitorable. So we more and more see a lot of devices in transactive energy deployment infrastructures where we can actually monitor whether the quantity and the quality of the energy that was promised actually is delivered. We have smart meters, we have various kinds of IoT devices along the way. So that's the kind of context where having smart contracts makes sense. Okay, so small, short-lived contracts that are essentially produced automatically and are used to monitor the execution of the legal obligations that are involved. Now, obviously, there are some issues with such platforms. So various common blockchain issues include the loss of keys that are used to encrypt information, denial of service attacks, erroneous or malicious nodes that exist on the network that try essentially to influence the voting mechanism that was mentioned earlier. But more precisely for energy markets, we have false data injection that can be used to actually tamper with smart meters that will store false information on the blockchain, which can influence not only the transactions, but also may have an impact on the physical devices involved and crash the system. This also can lead to some energy theft or even damages to the grid. More and more we see also issues with data privacy on such platforms. So you can actually, by monitoring the energy transfers and consumptions, profile who is using what, and infer knowledge about the presence or absence of people at their homes. Okay? So all of these side effects are very often domain dependent. So the question we try to face in my research group in Ottawa is how can we ensure that smart contracts will capture the intents of legal contracts and detect violations of terms and conditions and obligations during contract performance. And for that, over the past, I would say 4 years, we have developed a language called Symvolio, which is a Greek word that means to contract. And the idea is that Symvolio allows us to formally specify contracts in such a way that it enables formal analysis at design time so that we can reduce the likelihood of having bugs inside the system that will be deployed perhaps on a blockchain platform, which is very difficult to modify afterwards, and also generate code for those platforms. So we target one specific platform called Hyperledger Fabric in our work. So the idea is that we can encode, using that language, existing contract templates, including their various parameters, so that we can instantiate those contracts multiple times. So this is fitting essentially the kind of transactive energy scenario that I was talking about earlier. Well-formed contracts that will have a few parameters that will be set through the bidding process and then instantiated. And the idea behind the language is that we looked at a lot of existing types of contracts that can actually benefit from being monitored. So we're not necessarily interested in wedding contracts or contracts that target only one transaction, but essentially we're interested in long-term contracts where we have multiple occasions to observe what's going on and evaluate and assess the progress of obligations along the way. We developed essentially tools to create those contracts. They come with internal analysis features that will prevent essentially a few typical errors to be inserted. But we also created more sophisticated analysis tools that will try to anticipate all potential future behaviors of that contract for the various variables that it contains. And once we have something like this, we can check properties about liveness. So essentially, we want to make sure that good things will eventually happen by executing that contract, but also safety properties, where we want to make sure that bad things will not happen. And those properties will, again, be very domain-specific along the way. In our case, we built on top of existing technology for model checking, in particular NewXMV. So the idea is that we described our obligations and also powers, which enable modifying those obligations during the execution of the contract. And we convert that to that NewXMV format where we can specify our properties and essentially detect very subtle problems that could be embedded in those formal descriptions. One, we are satisfied that those formal definitions are correct with respect to the intents that were encoded in the properties. We can essentially try to push a button and generate an implementation of that contract for the Hyperledger Fabric platform. So we actually generate code. We target JavaScript as a language in our case, and then we can actually run the monitoring of the execution of legal contracts. So we did that, and we saw that essentially this enables saving a lot of effort and time with respect to having to encode the contracts manually. So we're targeting essentially faster ways of creating smart contracts of higher quality. We have recent publications in that context. So we have actually 2 papers to be presented next 2 weeks from now in Montreal as well at the Models Conference. And last week we had 2 thesis defenses. So Ali Reza finished his PhD and Aiden his master's degree on these topics. I'll make sure that those documents become available to the Cyber Justice Project people as well. So we're interested in engineering smart contracts as cyber-physical systems in a way that can monitor the execution of legal contracts and eventually perhaps even trigger some actions for financial transactions, for example. So Symvolio is a formal language that enables this through verification of properties and generation of smart contracts in a given blockchain-based platform. Now this is only the beginning. We still have quite a bit of work to do, for example, on the generation of those specifications, perhaps from natural language contracts. and also trying to better integrate various concerns that are not about the functions of the contracts or the obligations, but software engineering aspects related to security, to performance, to robustness, to where to put the information, because the solution is not always to store all information on the blockchain either. So this is what is happening next. Thank you.
Thank you, Daniel. And I think the next presentation is about how blockchain can be used by the justice system with Marina. An example.
Thank you, Benoit. Thank you, Daniel. So, for starting, a very quick but important thank you to Karim and all his wonderful team, and a big thank you to Alexandre for the perfect organization. It's an honor for me to be here. And I also would like to say that we learn a lot of things, but probably the most important is the links that we create all together, and we just meet wonderful people. So I'm very happy and to be here. So we take a step aside, and we leave maybe a little bit the cryptosphere and the question of energy, to quickly dive into another topic, because I would like to share with you an experiment we did at the faculty at Université Côte-d'Azur in France, because we carried out an experiment with our students to implement a blockchain in the judicial chain. And it seems to me that this experience could be interesting to share with you, because we asked ourselves many questions. I'm not really sure that we found all the good answers, but anyway, it was very interesting. And maybe that from a particular case, we could deduce general trends, which could be, of course, useful for all of us in the AJC projects. So we provided our legal support to develop a smartphone application called EOP. And so here it is. And this application aims to help people who are confronted with domestic violence. So people confronted with domestic violence, most of the time women. So this application is here to help women in difficulty. And we have found that many victims do not dare to file a complaint, because in fact they do not have enough evidence to convict their aggressor. So evidence is a key issue for improving legal proceeding, and it may be interesting to raise a question of how blockchain could be a way, finally, to improve access to justice. And this is why the EOP blockchain was created. So here is how it works. The victim uses a smartphone to capture evidence of violence in the form of photos or videos. These images are archived in a digital safe, and they generate information stored on the blockchain, which makes it possible to timestamp and certify the event. And to secure the victim, the photo or the video are immediately deleted from the victim's smartphone after being archived in a way on the blockchain. And then this application makes it possible to preserve evidence of domestic violence using blockchain. And if the victim wishes later, she can then transmit this evidence by filing a complaint with the criminal judge. So this application is, seems to us interesting. It's not, to my knowledge, not too difficult from a technical point of view, but what about from a legal point of view? And it's at this stage that the engineer, Julien Bonnel, needed a legal advice. So obviously, he couldn't afford the services of the law firm Beignet, Clef and Versteman. So he came to see us, and we did the job for free with our legal clinic. And then we have been working with the EOP developers for 1 year to highlight the legal aspect of using blockchain evidence in criminal proceedings. We understood that this use case would raise several legal difficulties at the crossroad between several fundamental rights, the legality of evidence on blockchain, the conflict between the right to a fair trial and the right to privacy, and finally the question, of course, of processing personal data with regard to the GDPR. We are in France, we have personal data, so of course we have to face with the GDPR. I also have to add a kind of a disclaimer, because I am under the eye of the data scientists and the engineers, so I would like to add that my team is not specialized in blockchain, so they are lawyers. And the works they did is about looking for the future, that is to say, trying to have a perspective, a vision for the future, raise this question, but maybe that the hypotheses or the assumption or the results are not the right one, maybe they are not accurate, but in any case, I think the exercise, nevertheless, deserves some insights. So, to sum up this work, the first issue is about the legality of digital evidence stored on blockchain. And of course, we know that evidence is at the core of the criminal trial, and the essential principle remains that of the presumption of innocence. So evidence is governed by three principles, mainly three principles: fairness, freedom, and legality of evidence. And we wondered if the use of blockchain technology could undermine this guiding principle. Especially, we wondered if we could, in a way, consider that evidence stored on blockchain could constitute an unfair or unlawful process. Maybe at one point that we could also discuss the fact that evidence on blockchain could infringe the right to privacy, maybe the right to a fair trial. So here are the main part of the discussion. So we'll see this point. The first of them is the question of admissibility of evidence that could be obtained unfairly or unlawfully. The principle of freedom of evidence prevails in criminal proceedings. So why not prove by blockchain, as the principle is freedom of evidence? Nevertheless, this freedom of evidence is subject to two other principles: legality and fairness. And the main function of the judge is to assess the evidence submitted to him. In theory, unfair or illegal evidence cannot be received in court. However, we made research on the recent legislation in France, and we found that the French legislator had considerably limited this principle. So we had to assess also the technical framework of the blockchain to be sure that this framework meets the legal requirements for producing evidence. And beyond that, it seems to us that other difficulties could arise, especially could the other party, could the defendant, allege a violation of its privacy right, and to go one step further, it's in fact a question of the infringement to the right to a fair trial. So what is the admissibility of evidence with regard to the right to a fair trial? We know that the Article 6 of the European Convention of Human Rights give a lot of importance to the right to a fair trial. We could also add another right, equality of arms between prosecution and defense. So how can we manage, in fact, to articulate, to find a right balance between using a blockchain and be sure that those rights are enforced. According to our research, evidence obtained without the author's knowledge could nevertheless be accepted by the judge, even if it violates privacy. One of the difficulties here was that the opposite party, the defendant, that is to say the aggressor, is not aware, of course, of the use of the blockchain. So the image, the video that is captured could be, in a way, be considered as an unlawful way of evidence. Criminal jurisprudence tends to admit illegally evidence more easily than in the past, and the French Supreme Court, the Cour de Cassation, admits the production of evidence in criminal matters that was so far excluded, provided that evidence complies with the principles of fairness and proportionality. And what is interesting here is that in the reasoning of the judges, reliability is an important argument to justify the admission of evidence obtained illegally. And of course, on this point, on the question of reliability, blockchain could be very useful because it appears to be a reliable technology. Maybe not as much as it should be, but anyway, it appears as being a reliable technology. So we concluded that the trade-off between the right to privacy and the admission of blockchain evidence would lead the judge to accept such evidence, even if it's obtained illegally or without the person's knowledge. But there is still an obstacle to overcome. Third question is the adversarial principle and the admissibility of digital evidence stored on blockchain. So the principle, the adversarial principle means that the defendant has a possibility to challenge the evidence, to discuss the evidence. So it appears to us that it was absolutely necessary to explain how the blockchain works, because it is a condition, in fact, to meet the requirement of the adversarial principle. And it's not always easy, in fact, to get into the functioning of the blockchain, but we had to do so because, in fact, the blockchain is not only a blockchain. It is a blockchain coupled with a digital safe. So in HIOP, the use of a blockchain works with a digital safe. EOP deletes the original document in the phone when its digital print is transferred to the blockchain to protect the user. And then a copy is generated in a digital safe. But it is only a copy, and it is important. So the interest of the copy, of the blockchain, is to certify that this copy has the same print as that of the original document. Thus, that means that the probative value of the copy depends on the ability of the judge and also of the defendant to understand the process of storing a document on the blockchain EOP. Because in fact, the defendant or the judge will not work with the original document, only with the copy, assuming that this copy conforms to the original, which has been coded and archived in the blockchain. And of course, we wondered if the replication of the evidence in the form of a copy could affect its admissibility in court. So it is a question of the probative value of a digital copy, which is then posed. So to answer this questioning, it was probably the easiest part, because in France there is a special legal regime which recognizes the validity of an electronic copy as provided by this article in the Civil Code. So we won't see all the conditions. They are here in these slides. We can just have a look at them. The legislator insists that the copying process must produce information related to the copy and so on, in particular the dates of creation of the copy, the quality of the process. It must guarantee the detection of any subsequent modification, and the copy must be kept under conditions to avoid its alteration. So, of course, we can deduce that all these criteria are met, since the blockchain, in fact, is definitely the technology perfect to guarantee optimal preservation of the copy. So we concluded that evidence by blockchain could be processed under the French law, provided that the condition laid down for the admissibility of electronic copies were met. And then there is a second aspect of the question, second part of my presentation, is a question about the personal data that are stored through the application. So the GDPR and blockchain, we know that it is a difficult issue. We've seen that once the evidence has been collected, of course, the question arises of the protection of the personnel data. And this raises several issues. First issue, which retention period for the document? Second issue, what about the consent? And then, how will work the right to erasure on the blockchain? So, to go quickly on the first question about the retention period of this document. We remember that the GDPR provides that personnel data cannot be kept indefinitely, so we have to provide for a retention period. And then, as data controller, we advise the EOP to provide for a data retention period that may be based on the limitation of the time for the prosecution. It was the most obvious way to solve the difficulty. Then, second question, more tricky one, is the question of the consent. Because consent is one of the obligations imposed by the GDPR so that the processing can take place lawfully. And then it is necessary to obtain the consent of the person. And for this, we advise the developer of hip-hop to add a setting in the application to ensure that the evidence is not directly recorded in the safe. That is to say that the victim must consent to the processing of the data through an affirmative action, that is to say just to press a button, but this is a way to be sure that there is the consent to validate the transmission of the data. We ask ourselves another question, more difficult, is that of the consent of the opposite party, that is to say of the aggressor. So of course we should conclude that we shouldn't ask this question, because of course if we ask the consent of the aggressor, there is no interest at all for the application. But anyway, under the GDPR, it's probably also his personal data that is stored in the blockchain. So what about his consent? And fortunately, the GDPR relaxes the rule of the consent when the processing of the data has a legitimate interest. So we advise the e-op developer to recall and to insist in the general conditions of use of the application on this notion on legitimate interest. And last point, the right to erasure. It is in the also a provision of the GDPR. The GDPR grants a right to erasure to data subjects. But of course, the implementation of this right can be complicated with regard to the permanent deletion of data registered on the blockchain. And in particular, a victim may want to erase data, although this data could be absolutely decisive years later during a dispute. So how to reconcile the right to erasure with the preservation of potentially admissible evidence in court? So in France, the Authority of Data Protection, the CNIL, came to temper the right to erasure in the event of use of the blockchain. And according to the CNIL, despite the fact that total deletion is technically impossible on blockchain, the removal of the hash function secret key has sufficient effects to guarantee the right to erasure. So, to conclude about this experiment, I just would like to say a few words about what this experiment had really taught to us. In fact, the very purpose of this experiment was to test the dialogue between engineers and lawyers. It wasn't easy at all. It was very interesting to think about the potential difficulties from a legal point of view, but it was even more interesting to challenge the data scientists and the engineers. And we tried to introduce finally a legal dimension at the root of IT application. And we had a concrete experience of what we call this legal by design. At the beginning, we had the feeling that legal difficulties were not taken seriously enough by engineers. But little by little, gradually, during our discussion, it appears that the legal dimension became totally a part of the technical dimension. So, it's over. Thank you.